appropriately attired for the trial before the jury. We've asked the jurors to report later this morning by 9:45 to 10 o'clock. There's a couple things we need to address on the record. I just asked the conference with counsel this morning and to readdress the issues of witness availability and continuing the trial. Counsel had requested that I essentially have a hiatus in the trial from today through Monday, May 20th, because of the difficulty with witness availability and other issues as we've discussed. Yesterday I was reluctantly agreeing to that, and after further consideration I declined to do so, predominantly because I don't want the jury to go 12 days without coming back to court and thinking about the case and its obligations to follow my instructions, not to be influenced by outside information. Even though we're not going to be able to go every day, I still think it's preferable to have the jury back next week. The state's indicated that it has no additional witnesses after today until one final position is available on May 22nd. So typically the state would have to rest after it called this last witness. Mr. Gallucci, would you confirm on the record that you have no objection to the state calling that last position on May 22nd out of order?
I do not, Judge.
Thank you. So then my proposal would be tomorrow we reconvene without the jury. There's a series of additional motions and hearings that the state has requested. In the event certain defense witnesses testify, we can still make productive use of time tomorrow. Mr. Gallucci had previously indicated that he has a family medical commitment on Tuesday the 14th, that's next week. So we're going to have trial on Monday and not Tuesday of next week, but my proposal now would be then, since we have a shortage of witnesses, not to have Monday, not to have Tuesday, because we were never going to have Tuesday, to have defense call whatever witnesses it can on Wednesday the 15th and Thursday the 16th, then to reconvene the following week on Tuesday the 21st for any additional witness testimony, any other hearings outside the presence of the jury if they're still necessary. Then on Wednesday the 22nd, the state's final expert can testify. Thursday the 23rd, the defense medical expert can testify. Both of those are difficult witnesses to arrange, and I'm sure they're expensive as well, since those physicians are entitled to be compensated for their travel and their time. So that's appropriate to give them solid dates. We have some buffer built in for Friday the 24th if there's any additional witnesses, and then counsel is asked to be able to work on their summations after review my final jury charge over Memorial Day weekend, with the thought of having closing arguments followed by jury charges on Tuesday the 28th, Monday the 27th being Memorial Day holiday. So my concern is we just let the jury go 12 days from today to the 20th, that you run the risk not only of outside influence, but people just becoming complacent and finding other reasons why they're not available, finding some family commitment, or perhaps even making up a reason not to come. I think it just goes too far. So anybody have anything like to place on the record in response to that?
No, thank you, Your Honor.
Hi, Mark.
All right, so in terms of telling the jury, you have no objections, but I give the jury those dates so they can plan. I'm sure they have to plan their work schedules.
No, Your Honor.
All right, and I'm just going to tell them this is a result of difficulty scheduling witness availability. People have other commitments, travel, as well as travel commitments to get here, and that's the best we can do, and we thank them for their patience and understanding. All right, there's nothing further. The court needs to place certain findings on the record in respect to some of the evidentiary rulings. So I'll proceed to do that. The court has allowed into evidence certain post-offense conduct allegedly committed by the defendant. The state previously filed 3 notices of motion in limine, which were scheduled for New Jersey Rule of Evidence 104 hearings on April 9, 2024, April 16, and April 17, 2024. On April 9, the state withdrew 2 of those applications, but the third application was for the admission of evidence of potential flight by the defendant. It was discussed on the record on April 9 and April 16. Although not withdrawn by the state, counsel on both sides asked the court to reserve a final decision on the introduction of evidence of flight until the trial. However, various aspects of the conduct which allegedly constitutes flight by the defendant were presented to the court at the 104 hearing on April 9. On that date, the court proceeded to hear testimony from Detective Sergeant Raymond Coles of the Ocean County Prosecutor's Office. This was prior to jury selection. That testimony included statements allegedly made by the defendant through text messages and other electronic records. The hearing was in part for the purpose of determining the admissibility of statements made by the defendant. The hearing also included authentication of video evidence retrieved from various sources, including the Atlantic Heights apartment complex and Southern Ocean County Medical Center. During his testimony, Sergeant Coles detailed the defendant's travels out of state shortly after the death of Corey and the alleged deletion of items from his cell phone. His testimony also included references to the internet searches allegedly conducted by the defendant. The court made certain findings at that time. The court incorporates its findings and conclusions, which were placed on the record on April 9 and April 16, 2024, as is set forth at length herein. At both the 104 hearing on April 9 and during his trial testimony before the jury yesterday, May 7, Sergeant Coles testified in detail as to his digital forensic examination of the defendant's Apple iPhone 11, which was seized from the defendant when his vehicle was stopped by law enforcement in Alcoa, Tennessee. At the 104 hearing, Sergeant Coles utilized a PowerPoint as a demonstrative aid to illustrate the defendant's travels from New Jersey to other states and the deletions from the defendant's phone. That was marked as State Exhibit S11 at the April 9 hearing. It included various subparts. However, S11 at that hearing is a different exhibit than S11 at this trial before the jury. Sergeant Coles established that the defendant's message retention settings on his Apple iPhone 11 were set to, quote, forever, close quote, meaning that text messages would have to be manually deleted. Testifying at trial as an expert without challenge to his qualifications by the defense, Sergeant Coles opined in the same fashion before the jury. Coles' testimony established that 881 pages, or approximately 3,466 text messages, were deleted from the defendant's cell phone. In contrast, those text message conversations were retrieved by Sergeant Coles from Brianna Micciolo's phone. In the court's view, Sergeant Coles properly discounted the possibility of any spoofing or fabrication of those messages by Ms. Micciolo, and I'm convinced that his testimony establishes the grounds for authentication of all of that evidence under Evidence Rule 901. Exhibit S11G at the 104 hearing was presented, where Coles presented a map showing the defendant's GPS location data from the defendant's iPhone, detailing his travels from New Jersey through various states to Arkansas and later Tennessee. His testimony established that there were approximately 60,000 GPS location data entries from New Jersey to the southwest corner of Arkansas from the evening of April 2nd through April 3rd, 2021. Although Coles admitted at both the 104 and at trial on cross-examination that he did not know for certain when the text messages were deleted, a logical conclusion can be drawn that the messages had to be deleted after the time they were created and before the defendant's iPhone was seized by law enforcement in Tennessee, just days after Corey's death. The record establishes the phone was seized in Tennessee on April 4, 2021. Therefore, we're talking about approximately 2-day window from Corey's death on April 2nd to the time the phone was seized, held by Tennessee law enforcement, and later taken into evidence by Ocean County detectives when they traveled to Tennessee for the purposes of searching the defendant's car, seizing his phone, and other electronic evidence. Coles also detailed the internet searches made by the defendant post-offense, that is, after Corey's death, on April 2nd through April 4, up until the time of the seizure of his phone. These internet searches included searching for medical terms and conditions like loss of consciousness, sleepiness, nausea. Searches such as, quote, can my car be tracked? Quote, can my iPhone be tracked in airplane mode? Close quote. And words to the effect of what causes a rise in blood sugar or white blood cell count. Tellingly, 2 additional searches were conducted with words to the effect of, quote, how long from autopsy to charges? End quote. Those were actually 2 different searches, but substantially the same type of inquiry. Additional searches were conducted on causes of internal bleeding and the like. The court finds that these post-offense searches are relevant and highly probative evidence for the jury to consider as to the defendant's intent, and that this evidence can be properly presented to the jury with a limiting instruction. The court likewise finds that evidence of defendant's flight and deletion of text messages after Corey's death are relevant and again highly probative, also subject to a limiting instruction advising the jury how to consider that evidence. For instance, as to the evidence of flight, the following are apparent. A defendant left New Jersey shortly after Corey's death. The records show that Corey was pronounced at 5:03 p.m. and video shows defendant leaving Southern Ocean County Medical Center at 5:20 p.m. Second, defendant did not simply travel to another location in New Jersey or even to a relative's home or a friend's home in a contiguous state. He traveled a substantial distance across several states. Third, the GPS coordinates introduced by Sergeant Cole established defendant traveled hundreds of miles across several states as far as southwest Arkansas and Tennessee, all in a relatively direct fashion in a reasonably short or contemporaneous period of time to Corey's death. Four, defendant was the person last seen with Corey. He brought him to the hospital and left the hospital knowing Corey was either already dead or dying, depending on which testimony you believe. But the videos played for the jury yesterday clearly established the defendant appeared distraught and upset. Hospital staff provided him with a chair to sit down and even brought a privacy drape over as the defendant was leaning over, holding his head in his hands. And Nurse Carnevale was testifying that Corey had seized, his heart had stopped. They began life-saving techniques. Corey had to be intubated. A pulse was briefly regained, but then lost again. So whether the defendant left after all that was over or shortly before it was all over, the defendant clearly knew that Corey's life was in jeopardy, if not positive, it had ended. This would lead any reasonable person to know he or she would be subject to an investigation under those circumstances. That the defendant was the last person having care and custody of Corey when he was brought to the hospital in what really amounts to the final moments of his life. 5. Sergeant Coles detailed that Sergeant Cerulli, Cirulli, of the Barnegat Township Police Department made efforts to reach the defendant immediately after Corey's death. The forensic examination showed Sergeant Cerulli attempting to call the defendant at 5:48 p.m. on April 2nd, 2021. This would have been approximately 28 minutes after the defendant had left the hospital. Sergeant Coles established that the call was rejected from the defendant's iPhone 11. Sergeant Cerulli placed a second call shortly thereafter the defendant's phone, which instead continued and became a, quote, missed call, close quote. Anyone in that position would have likely been alerted that law enforcement was seeking to contact him and that an investigation, an accusation, or a charge was being contemplated. During this same period of time, defendant is conducting searches on his phone in an attempt to evade. For instance, after leaving at 5:20 and after receiving calls from Sergeant Cerulli at 5:48 and shortly thereafter, at 6:10 p.m., again about 20 minutes after Cerulli's trying to contact him, perhaps even less, 15 minutes, defendant conducts a search on his iPhone, quote, "Can my phone be tracked in airplane mode," end quote, and, quote, "Can my car be tracked," close quote. The court finds that those messages are highly probative of an attempt to flee, of defendant's state of mind at the time, as I'll further discuss. Moreover, ordinary persons can't typically track someone's cell phone or car unless it's somebody that you're very close with and you've chosen to share your own location services with them on your device. Any reasonable person would take those comments to mean, can law enforcement track the defendant's phone in airplane mode or track the defendant's car? 6, the period of time in which defendant was fleeing New Jersey also gave the defendant an additional window of time to delete the messages, search history, and or emails which Sergeant Coles testified had been deleted from his defendant's phone and had to be deleted manually from the defendant's phone based upon his settings. This allowed the defendant to accomplish that before the police were able to seize the phone, something that law enforcement was not able to do until 2 days later after the defendant was stopped in Alcoa, Tennessee. 7, defense counsel has suggested the defendant has explanations for his travels out of state and or his conduct in making certain internet searches and deleting certain items from his phone. Those explanations include, but may not be limited to, possible threats the defendant was receiving. By having an alternate explanation, this allows the court to instruct the jury to consider the explanation of defendant in comparison to the state's allegations of theft, as the Supreme Court has directed trial courts to do. See State v. Mann, M-A-N-N, 132 New Jersey 410 at 421, a 1993 Supreme Court case. Therefore, I conclude, after a careful analysis of the evidence as directed by the Supreme Court in the Mann case at 420, that in this case, there is a high degree of confidence that inferences can reasonably be drawn from 1, defendant's behavior to flight, 2, from flight to consciousness of guilt, 3, from consciousness of guilt to consciousness of guilt to the crime charged, namely murder, and 4, from consciousness of guilt to actual guilt. Therefore, I conclude that evidence of flight has been properly presented to the jury, and the jury has been properly instructed on the limited and specific purposes for which it can consider this evidence. We did this by having prior hearings, as well as the agreement of counsel for the court to delay its final ruling on this matter until today. Counsel also approved a specific jury instruction, which has been previously circulated, discussed on the record, and provided to the jury. That was Exhibit C4, the court's exhibit on a limiting instruction to the jury, which was first marked into evidence as a court exhibit on April 30, 2024, with the input from defense counsel. Next, the court will also discuss the internet search history and the deletion of text messages or other items from the defendant's phone. The communications between defendant and Corey's mother, as well as others immediately prior to Corey's death, and his internet searches on April 1, 2021 and April 2, 2021, before Corey's death, are, in this court's view, intrinsic to the crimes charged and were committed contemporaneously with the alleged offense. Therefore, they are not post-offense conduct, and they've been properly admitted by the state. In addition, however, the state has sought to admit additional post-offense conduct of the defendant, meaning after Corey's death, in regard to internet searches by the defendant and deletion of items from the defendant's iPhone. The analysis of this post-offense conduct is similar to the court's analysis of the defendant's flight. Regarding post-offense conduct, this court relies upon and is guided by certain well-settled law, including State v. Williams, 190 New Jersey, 114 at 125, the 2007 New Jersey Supreme Court case, and State v. Rochat, R-O-C-H-A-T, 470 New Jersey Super 392 at pages 455 and 56 in a television case from 2022. To establish that such conduct committed after an offense is admissible to establish consciousness of guilt. In the Rochat case, the court dealt with post-offense conduct of the defendant in that case, refusing to cooperate with police, with resisting arrest when he was pulled over after the fact. The court permitted that type of conduct to be introduced to the jury, and that ruling was affirmed on appeal because the trial court properly explained the permitted and prohibited use of that evidence. State v. Williams is a case which is particularly appropriate in this regard. This is really as to both the flight and the post-offense conduct on the internet searches and deletions. Williams was a famous defendant who had been an NBA basketball player, and after retirement was a sportscaster and a person of some notoriety. When he had people over his house who had been chauffeured by a limo, the limousine driver was in the home when Williams was handling a collector-type shotgun. Williams discharged the shotgun and the limo driver died. Williams allegedly engaged in a series of actions after that to cover up the scene, to make it look as if the limo driver had committed suicide. He wiped down the weapon of his own fingerprints, put the decedent's hands on the shotgun, and did a variety of other things to discard certain evidence of blood, and he also prompted witnesses to tell the police that the limo driver had committed suicide. The case is noteworthy for the fact that it stands for the proposition that when someone's charged with committing an offense which requires specific intent, such as purposeful and knowing conduct, like murder, post-offense conduct demonstrating evidence of or consciousness of guilt is typically admitted. The issue in the Williams case was he was not charged with murder, he was charged with aggravated manslaughter and a lesser included charge of manslaughter. He was acquitted of aggravated manslaughter, found guilty of some lesser offenses which were accepted by the court, and then he was going to be retried on manslaughter. The defense sought to exclude the post-offense conduct because the state of mind for the manslaughter charge was recklessness. So the Supreme Court went to great lengths to show why, even for recklessness, which is not specific intent like purposeful or knowing conduct, other crime evidence can be admitted. In doing so, the Supreme Court employed the familiar four-part test from State v. Cofield, C-O-F-I-E-L-D, which this court will also address in a moment. The first prong of which is the evidence must be relevant to a material issue. The second prong, it must be similar in kind and reasonably close in time to the offense charged. Third is that the evidence of the other crime must be clear and convincing. And fourth is the probative value of the evidence must not be outweighed by its apparent prejudice. The Williams case goes through great detail as to why post-offense conduct such as the conduct committed by defendant Williams and the conduct allegedly committed herein by this defendant are highly relevant to a state of mind. A mental state is not conducive to demonstration through direct evidence. This court's jury instructions will tell the jury that purposeful and knowing conduct are conditions of the mind, which are rarely, if ever, submitted by direct evidence. The state is not required to call someone to testify that the defendant said he thought a particular thing at the time he committed a particular act. Mental state is rarely, if ever, capable of direct proof. In criminal prosecutions, the Supreme Court has made clear that proof of the defendant's mental state must often be inferred from the circumstances, and the jury must take into account those surrounding circumstances committed immediately before, during, and after the alleged crime to determine defendant's mental state. When an individual's state of mind is at issue, a greater breadth of evidence is allowed, including circumstantial evidence that has a tendency to shed light on the defendant's mental state and which tends to fairly explain his actions, notwithstanding the fact that the evidence relates to conduct that occurred before or after the offense. And that's the Williams decision at pages 125 and 126. The court has specifically recognized that relevance of post-crime conduct with respect to a defendant's mental state demonstrates consciousness of guilt, and I incorporate all of those other cases cited by the Supreme Court in the Williams case. In conclusion, the Supreme Court found that, quote, such evidence belongs in front of the jury. Objections thereto should be evaluated by the jury as part of its weighing of the evidence. End quote. And that's the Williams decision at page 127, citing State versus Brown, 118, New Jersey 595 at 615, a 1990 New Jersey Supreme Court case. In the Williams case, the Supreme Court found that the defendant's post-defense conduct could support inferences having a logical tendency to prove that the defendant was aware of the victim's fatal injuries and that they were not the product of an accident, but were caused by Williams' reckless conduct, as was the theory of the state's case. By analogy, that language applies with equal force here, as the state contends that the defendant's post-defense conduct has a logical tendency to prove the defendant was aware of the child's injuries, that they were fatal and they were not the product of an accident, even though the defendant proffered explanations such as football injuries or others as possible accident. In fact, the Williams case rationale applies with even greater force here, because the defendant is not simply charged with crimes dealing with recklessness, he's charged with purposeful and knowing murder, and both sides have agreed that this court will likely instruct the jury on lesser included offenses of aggravated manslaughter and manslaughter. So therefore, this jury would consider purposefully, knowingly, and recklessly as levels of culpability in connection with all of those matters. With respect to the second prong of the Cofield analysis, and this is with regard to both the flight and the internet searches and deletion of items, the second prong does not have universal application. Its usefulness as a requirement is limited to cases which replicate the circumstances in the Cofield case, which dealt with drug use. In Williams, the court found that the application of the second prong served no beneficial purpose and disregarded it. Here the court agrees, but nevertheless, even if it applies, clearly the conduct immediately after leaving the hospital through the evening of April 2nd and April 3rd on to April 4th is no doubt, quote, reasonably close in time, close quote, within the meaning of that second prong. The third prong is clear and convincing evidence. Here the court is satisfied that the evidence of defendant's travels to Tennessee and Arkansas and his internet search history, as well as deletion of his items from the phone, has been established by clear and convincing evidence through the detailed and meticulous forensic expert testimony from Sergeant Cole, supported by his detailed explanations as to how the information was acquired and extracted from the defendant's phone, Ms. Micciolo's phone, and analyzed in the high-tech laboratory. The final requirement is whether or not the evidence of post-defense conduct its probative value of that evidence is outweighed by its apparent prejudice. So all evidence in favor of the state is prejudicial to the defendant. However, the Supreme Court in Williams made clear that, quote, the fact that the evidence casts defendant in an unflattering position is not a reason enough to exclude it, close quote. Interestingly enough, in the Williams case, the trial judge excluded the evidence, and the state was appealed, and ultimately when the Supreme Court heard the case, the Supreme Court found that the trial judge was mistaken by trying to keep that information from the jury, particularly where a defendant would be able to provide alternative explanations for his post-offense acts. The jury is left to draw its own conclusions, which may include very well rejecting the state's view of the evidence. The jurors could believe the defendant's post-offense conduct was due to other things, which in the Williams case the defendant suggested. In this case the defendant can suggest, and we've discussed that. In fact, I even tailored the proposed limiting instructions based upon input from counsel. Here I find that the jury clearly understands things like internet searches, GPS location data, text messages, and it's fair to say today that the use of very sophisticated smartphones and iPhones is common knowledge. These smartphones are ubiquitous. Everybody has one, everyone uses one. We know that just simply we collect all the jurors' smartphones and devices when they come in the courtroom. So this is not difficult information for the jury to understand. The jury is able to analyze it in the context of all the evidence in the case, and it is not unduly prejudicial to the defendant. The court crafted limiting instructions about the post-offense conduct searches and his post-offense deletion of items in consultation with counsel, and those have been already marked into evidence as Court Exhibits C11 and C12, and the court modified them slightly to address concerns by defense counsel. I find that these instructions properly advise the jurors how to use this evidence and to disregard the evidence if they either find it not helpful or not indicative of consciousness of guilt. And that's in accordance with both the Williams opinion and the Rochat opinion. And this analysis is equally true with respect to the flight. In State v. Long, 119 New Jersey, 439 and 499 in 1999 case, the court specifically discussed that flight of an accused is admissible as evidence of consciousness of guilt and therefore actual guilt. A flight instruction is appropriate where there are circumstances present and unexplained which reasonably justify an inference that it was done with a consciousness of guilt and pursuant to an effort to avoid accusation based on that guilt. State v. Latney, L-E-T-N-E-Y, 415 New Jersey Super 169 at 175-76, an appellate case from 2010. The jury must be able to find departure and motive which would turn the departure into flight. And that's the Latney case at 176, and quoting State v. Wilson, 57 New Jersey, 39 at 49, a 1970 New Jersey Supreme Court case. The New Jersey Supreme Court has already adopted a model instruction on flight, which the court has already given in this case with a slight modification as requested by defense counsel. In part, that instruction provides that if the jury finds that the defendant, fearing an accusation or arrest, will be made against him or her on a charge involved in the indictment, took refuge in flight for the purpose of evading the accusation or arrest on that charge, then the jury may consider such flight in connection with all the other evidence in the case as an indication of proof of consciousness of guilt. Again, this was an agreed upon charge which was marked into evidence as Court Exhibit C4. That being said, the court must be cautious that mere departure, however, does not imply guilt by itself, as flight requires departure from the crime scene under circumstances that imply consciousness of guilt. State v. Ingram, 196 New Jersey, 23 at 46, a 2008 case, also quoting the Long case at page 499. In the Wilson case I cited previously at page 49, the court stated, a jury may infer the defendant fled from the scene of a crime by finding that he departed with an intent to avoid apprehension for that crime. It is not necessary that he flee from custody or that he be found hiding. End quote. That's particularly appropriate here as defense counsel has claimed the defendant was apparently going to come back. Regardless, the question is whether the evidence in the trial has reached a tipping point that the departure to avoid detection or apprehension is present in the case. Here, the court has no hesitation in finding that evidence reached the tipping point contemplated by the court, and that is in regard to both the flight and the internet searches and the, I shouldn't say both, all three, flight, the internet searches, and the deletion of items on the phone. The volume of the evidence deleted, the flight, coupled with the highly probative nature of the internet searches, particularly searches like, quote, how long after an autopsy till charges are filed, end quote, allows the jury to properly draw an inference of consciousness of guilt to consciousness of actual guilt, should it choose to do so. The defendant's deleted text messages with the mother of the child, those text messages having occurred in the days and several hours before the child's death, are highly relevant. Many of those messages include discussions of obtaining treatment for Corey at a pediatrician on the afternoon of April 1st, thereafter at Community Medical Center in the evening, and thereafter at Jersey Shore University Medical Center during the late night hours, even into the early morning hours of April 2nd, ultimately involving communications about the child being taken to Southern Ocean County Medical Center on the afternoon of April 2nd. These are not the kind of items on one's phone that one would expect an innocent person to delete after a child dies, especially after the child was in one's care and custody for the few hours immediately before the hospitalization. What weight should be placed on these items and the defendant's post-offense conduct is for the jury and the jury alone, but I conclude it has all been properly presented to the jury and that appropriate limiting instructions have been given at the time of the presentation of the evidence and will be given again in the court's final instruction. I appreciate everyone's indulgence with me placing that long decision on the record, but given the manner in which the court conducted these hearings, that the state had called witnesses on various other occasions, I wanted to have one occasion where all of this was placed together so as not to have a search through various days of transcripts to be able to have that reviewed if necessary on appeal. I've been advised that all jurors are present. Is there anything else we need to discuss outside the presence of the jury?
No, Your Honor. Thank you.
No, Your Honor.
All right. Get the jury, please.
I don't know. They're in the hallway.
too.
Somebody needs.
Anybody needs to use the bathroom? All right, give me an
Please
option.
be seated.
Okay, thank you.
Right now? Andrew, what do you mean first?
I'll be right there. All right, Your Honor, we good?
Yes, it's 10:13 a.m. jury up.
Jury out.
Thank you. Please be seated, everyone. Ladies and gentlemen, we have a new court reporter today. Ms. Rachel Chicklese is a veteran reporter from another county, but she's here to help us out today. Any concerns or issues we need to discuss at all? Okay, seeing none, we'll proceed with the state's next witness.
Thank you, Your Honor. The state will call Dr. Thomas Andrew, please.
Hi, doctor. Good morning. Good morning. Come on up. Thank you, doctor. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I so affirm.
Thank you. Please have a seat. Doctor, would you state your full name and spell your last name?
Thomas A. Andrew, A-N-D-R-E-W.
Thank you so much.
Good morning, doctor. Can you tell the jurors what type of doctor you are?
I'm a forensic pathologist.
Your Honor, if I may approach with
Yes, of course.
S49, counselor? Okay.
Thank you.
Doctor, I'm now going to show you what has been marked S49 for identification purposes. And do you recognize that?
I do.
And can you tell the jurors what that is?
This is what appears to be the most recent iteration of my curriculum vitae, my qualifications.
And would that aid your testimony today?
Sure.
Now, doctor, can you tell us what your fellow is in?
I did a fellowship in forensic pathology after having completed a residency in anatomical pathology in a different institution.
And what about your fellow in pediatrics?
I went to medical school at the University of Cincinnati in Cincinnati, Ohio, and then matched in a pediatrics residency program at Cincinnati Children's Medical Center. So I'm initially trained as, and I practiced as, a pediatrician in Cincinnati prior to changing directions and going back to the University of Cincinnati to do the residency in anatomical pathology and then the subsequent fellowship in forensic pathology.
And how long were you a pediatric doctor for?
I started my training in 1982, and I left for my anatomical pathology training in 1988. I continued to work as a pediatrician, moonlighting at the Children's Emergency Room and at an urgent care center in Cincinnati during the 3 years I did my anatomic pathology residency. But the last specifically pediatric work I did was in 91.
And where did you do your anatomic pathology residency at?
That was at the University of Cincinnati College of Medicine from 88 to 91.
And can you tell the jurors about your fellow in forensic pathology?
After I completed my training in anatomical pathology, I applied for a forensic pathology fellowship, that's subspecialty training, with the Office of Chief Medical Examiner in New York City. I interviewed and got that position, and I did my fellowship there in 91, and then was invited to stay on staff as a city medical examiner for the city of New York, and I did that until early 97, and then was named acting deputy chief for Richmond County, which is one of the 5 boroughs. It's essentially Staten Island. So I was acting deputy chief for that particular borough until I left New York to assume the role of chief medical examiner for the state of New Hampshire.
And how long were you chief medical examiner for the state of New Hampshire?
20 years. I served from September of 97 and retired from state service in October of 2017.
Can you tell the jurors what board certifications you hold?
I'm boarded by the American Board of Pediatrics in Pediatrics and the American Board of Pathology in Anatomic Pathology and Forensic Pathology.
Can you tell the jurors about some of your academic appointments?
Well, when you're chief medical examiner or affiliated with the medical examiner's office, you get some automatic academic appointments. And when I was in New York, I had an appointment at SUNY and an appointment at Bellevue. But then when I went to New Hampshire, I had an appointment at the Dartmouth Medical College, and also did teaching for the Massachusetts College of Pharmacy and Health Sciences and a physician assistant program affiliated with Franklin Pierce University. I don't have any of those positions anymore because I retired. The only academic position I currently hold is as an adjunct professor of forensic pathology for the medical school at Boston University.
Are you currently a member of the New Hampshire Child Fatality Review Committee?
I'm currently not a member of that committee. However, I was for the 20 years that I served as chief medical examiner.
Have you ever testified as an expert witness in court before?
Yes.
And about how many times have you testified?
It's in the low 3 figures.
And what types of cases have you testified in?
Well, in that my testimony has been exclusively in the area of forensic pathology, they have basically been involving issues regarding the interpretation of patterns and mechanisms of injury and cause and manner of death. These can be anything from natural deaths or accidental deaths, suicidal deaths, or homicidal deaths.
Have you ever been published in the area of pathology or pediatrics?
Yes.
And can you just give the jury some examples of those?
Well, most of my pediatric publications are in the area of child abuse and neglect and sudden unexpected infant death and the investigation of sudden unexpected death in infancy and childhood. I have other publications that are not necessarily germane to this proceeding, but other publications in various aspects of forensic pathology, gunshot wounds, drug deaths, that sort of thing.
And have you ever engaged in speaking engagements relating to those topics?
Yes.
And about how many autopsies would you say have you performed during the course of your career?
In the neighborhood of 6,000 or so.
And about how many pediatric autopsies have you performed during the course of your career?
I don't log those separately, but they're probably in the range of 500 or so.
Your Honor, the state is seeking to offer Dr. Andrew as an expert in the field of forensic pathology.
No objection.
The court grants the state's application for Dr. Andrew to testify as an expert in the field of forensic pathology. Ladies and gentlemen, I have to give you that instruction again with respect to expert testimony. As I said to you with respect to prior experts, as a general rule, witnesses can only testify as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness who may give his opinion as to any matter in which he is versed, which is material to the case. In legal terminology, an expert witness is a witness who has some specialized knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and determining the facts in the case. In this case, the state has called Dr. Andrew as an expert in forensic pathology. You are not bound by such experts' opinions, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon, and no stronger than, the facts on which it is based. In other words, the probative value of the opinion will depend upon whether, from all the evidence in this case, you find that those facts are true. You may, in fact, determine from the evidence in this case that the facts that form the basis of the opinion are true, are not true, or are true in part only. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your finding as to the truth of the facts relied upon. The ultimate determination of whether or not the state has proven defendant guilty beyond a reasonable doubt is to be made only by the jury. As with all those charges, I'll again give you that charge in the final jury charge at the end of the case. Ms. Lento.
Thank you, Judge. Doctor, were you contacted by the Ocean County Prosecutor's Office in regard to the decedent, Corey Micciolo?
Yes.
And can you tell the jurors why you were contacted?
I received initial contact from the Ocean County Prosecutor's Office in September of 2021. They asked me to review material related to the death of Corey Micciolo with an eye toward rendering an opinion as to cause and manner of death.
Now, Doctor, did you prepare reports in regard to your findings and opinions regarding this matter?
I did.
Your Honor, if I may approach counsel?
Yes.
Thank you. If I may approach, Doctor, I'm now showing you what has been marked S50, S51, and S52. Do you recognize those?
I do.
And can you tell the jurors what those are?
S51,
Are those your reports in this matter?
yes.
And would those reports aid in your testimony today?
Yes.
Now, did you perform the autopsy of Corey?
No.
Can you tell the jurors who performed the autopsy?
Dr. Ragasa, Dante, I believe is his first name, Dante Ragasa, of the Ocean County Medical Examiner's Office, performed the autopsy examination on Corey.
And when was the autopsy performed?
Autopsy was performed in April of 2021. Let me see what the specific date was. On the 3rd of April, 2021.
And did you review the autopsy report authored by Dr. Ragassa?
I did.
And what other materials did you review to formulate the basis for your opinions?
In addition to the autopsy report, I saw the images that were generated in association with the autopsy. And I examined the histological slides, and we'll talk about those momentarily. The slides that you look at under the microscope. So I looked at that. And then I had medical records from 3 different hospital facilities. I believe it's County Medical Center and Jersey Shore Medical Center and South Ocean. I saw medical records from IV Pediatrics, which were Corey's pediatric care provider. Certainly I saw police documentation, law enforcement documentation. I saw some telephone records. I had access to a video of Corey on a treadmill. And subsequent to issuing my first report, I received additional materials. I did receive an expert report from an infectious disease specialist, Dr. Feingold, and a report from a defense pathologist expert, Dr. Bodden.
Did you also review a video from April 2nd of 2021 from the decedent's mother's phone occurring around 9 a.m.?
Indeed, I did, yes.
And you also reviewed autopsy photos?
Yes.
Do you have an opinion, after you reviewed all of this material, in regard to the decedent's cause of death?
Yes.
And can you tell the jurors what that opinion is?
I'm simply going to quote from my report, because it's a mouthful, and we'll break it down. But Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver.
And can you explain to the jurors, when you say cause of death, what does that mean?
Cause of death is, it sounds simple enough, but it's something that's very specific. Cause of death is the disease or injury or combination of those things that initiates what's ultimately a lethal train of events, and without which death would not have occurred. So there are many, many, many causes of death.
And what about blunt force trauma? Can you explain to the jurors what that means?
In forensic pathology, there are various kinds of external forces that can act on the body. There could be penetrating trauma, such as that from gunshot wounds or stab wounds, or there can be blunt impact injury. And in that situation, you have force applied to the body over a much broader area than a single bullet or blade would cause. That blunt impact could be a small area or a large area, but it produces a different kind of injury than penetrating trauma does. And the kinds of injuries associated with blunt impact include contusions or bruising of the skin or internal organs, lacerations, tearing of tissue because of the result of the blunt force applied to it, or fracture of bone.
And what affects blunt force trauma and the impact on the body?
Well, the impact can be anything from minor to life-threatening. If you get up in the middle of the night in a strange hotel room and hit your shin against a nightstand, that may raise a contusion. But all that is bleeding under the surface of the skin, and that will resolve over time, and that will be fine. If you were to fall against that nightstand, you might sustain a laceration of your scalp. That may require stitches, but likewise you would recover from that. If you sustain any of these kinds of blunt impact injuries with sufficient severity, it could conceivably bring about your death if they were severe enough.
After reviewing the materials in this case, did you formulate an opinion as to the decedent's manner of death?
I did.
And can you tell the jurors what your opinion is?
Corey's manner of death is homicide. While there are many, many, many causes of death, typically in forensic pathology, there are only 5 manners of death. And manner of death is simply a one-word description to explain how a death came about. And those 5 are natural, accident, suicide, homicide, or in rare instances, undetermined. In Corey's case, in that these injuries could not have been inflicted by himself with any kind of intent, it's certainly not suicide. These injuries, given their pattern and distribution, are consistent with having been inflicted by another person. Therefore, any death that is related to the actions of another person is, from a medical examiner's standpoint, from an epidemiological or public health standpoint, homicide. Now, it doesn't have any legal significance, but that's the way that a medical examiner certifies it. So Corey's death was at the hands of another person, therefore it is a homicide.
Does a case histology impact the determination of manner of death?
Well, it can in certain instances. If you have a gunshot wound to the head with a perforation of the skull and brain, histology or examining tissue under the microscope doesn't add a whole lot. But in a case like this, certainly the examination of the tissues under the microscope was helpful in reaching my conclusions.
Did you make any findings regarding Corey's medical records from Southern Ocean Medical Center on April 2nd of 2021?
And I'm going to ask you to clarify that a little bit because I'm not entirely certain what the question is.
Did you review the medical records from Southern Ocean Medical Center on April 2nd of 2021?
Yes, I reviewed those records from April 2nd.
And can you tell the jurors if that helped to formulate your opinion as to cause and manner of death?
It did, yes.
And can you explain why?
Well, Corey presented to Southern Ocean at around 3 o'clock. At that point, he was already in serious medical condition. He was ashen, gray, in a shock-like state, and was fairly medically unstable. There was an attempt to make an assessment as to what might have been going on with him by doing a CT scan, and he got worse in the CT scanner to the point where he underwent a cardiac arrest.
And doctor, did you review any blood work from that hospital?
Yes.
And did that impact your conclusions?
Yes.
And what about any post-mortem CT scans?
He had a post-mortem CT scan. I don't find those of particular value, certainly compared to an autopsy, as to determining cause and manner of death. But I did see that there was a post-mortem CT scan, and I looked at its result.
Did you review the medical records from Jersey Shore Medical Center the evening of April 1st of 2021?
I did.
And can you tell the jurors about that?
Well, that particular visit was at the end of a sequence of events wherein Corey initially was seen by his pediatrician. There were some concerns about these bruises that Corey had as to whether or not this represented some mistreatment or child abuse. So Corey was referred to the emergency room, and I believe Corey and his mom went to one, but then they went to Jersey Shore after that. At that examination, he had a physical done, and they documented the various bruises that he had on different parts of his body, none of which were life-threatening. His clinical status at the time was perfectly stable. He was normal. He was conversational. He spoke with the doctor. He gave history. He made some disclosures. They also did some blood work and an x-ray of his chest, and all of that was completely normal.
Did you review the findings from Dr. Ragassa's autopsy performed on April 3rd of 2021?
I did.
And can you tell the jurors what Dr. Ragassa's findings were?
So Dr. Ragassa received, the body was taken to the medical examiner's office, I believe, the night before, but Dr. Ragassa performed his examination on the 3rd and documented all of the bruises or contusions that were on various aspects of Corey's body. Those were the primary external findings that he had. But an autopsy is a very detailed surgical examination of not only the external aspect of the body, but the internal aspect as well. There's a large Y-shaped incision made from the shoulders to the middle of the chest and down the center of the body, allowing the pathologist to take a systematic examination of each of the organ systems. It was during that internal examination that Dr. Ragassa saw and documented several abnormalities. There was a large contusion of one of Corey's lungs, I believe it was the left lung. Examination of Corey's heart externally didn't show anything, but on the internal examination of the heart, after the heart was opened to reveal the chambers of the heart, a laceration or tear in the tissue was revealed near the apex or the tip of the heart, on the inside wall of the heart. Below the diaphragm is that flat muscle that divides your chest organs from your abdominal organs. Below the diaphragm, on the right side where the liver lives, there were two injuries that he documented. There was a laceration or tear in the liver tissue on the right edge, the right lateral aspect of the liver, and there was also a contusion or bleeding underneath the capsule of the liver on the front edge of the liver. There was a small amount of free blood in the floor of the pelvis, undoubtedly associated with the liver laceration.
Now, doctor, did you review slides which were prepared in conjunction with the autopsy?
Yes, I did.
And can you tell the jurors what the slides are?
This was what I was referring to when I used that term histological. These are not slides like old 35 millimeter photographic slides. This is something different. During the internal part of the examination in an autopsy, small tissue samples of areas that look normal or abnormal can be taken, and then they are processed by a laboratory such that they're cut in very, very thin slices and floated onto a glass slide. That tissue is then stained with specific kinds of stains that allow the pathologist to then see the cells under the microscope. So I did see the entire set of histological slides that Dr. Ragassa had prepared in conjunction with his autopsy.
Did you also review autopsy images?
Yes.
And can you tell the jurors specifically what image 151 depicted?
Image 151 was of a pulmonary contusion, meaning a blunt injury of the lung associated with bleeding. Now, there was a picture of it. It's obviously that you can see. It's obvious that you can see it. It does not appear in his narrative description, but it's depicted in the photographs.
And can you tell the jury about image 153?
Well, I'll have to refer to my report on
Yes,
that.
doctor, if you could.
Oh, 153 was a picture of the free blood that was in the pelvis.
Can you tell the jurors about images 163 through 170, please?
Those were various views from different angles of the liver injuries.
And what about images 172 through 178?
Those depicted injuries in different parts of the body. 172 to 75 were hemorrhage in the retroperitoneal tissue. Sorry about the jargon, but I mean, that's where it was. What is that? The abdomen is lined by a lining called peritoneum. Retroperitoneum means bleeding underneath the peritoneum, and this was toward the back of, where the backbone is. 76 to 78 was similarly hemorrhage. It was contusion, and it was in the area of his left ninth rib. That may well be what was associated. That trauma on that side may well be what was associated with the contusion of the lung itself on that side. And then, yes, so that takes us up to 178.
Okay, doctor. And did you review images 196 through 200?
Yes.
And can you tell us about those?
These images were, I should preface this. I explained when I was talking about when an autopsy is approached in general, how you do that incision in the front. In cases where it is important to do, the death of somebody in police custody, for example, or in this case, a potential child abuse case, you do a similar examination of the back. So you turn the body over, and an incision is made along the midline of the back, and that skin is reflected so that you can see the muscles of the back. These images, 96 to 200, or excuse me, 196 to 200, depicted soft tissue hemorrhage or contusions along the spine or the backbone that you could not see necessarily on the surface of the skin. There were certainly contusions on Corey's back, but there were also contusions that did not correlate with deep contusions that didn't correlate with contusions that were on the skin.
Can you tell the jurors about the myocardial laceration depicted in image 0205?
Yes, and this is complicated. So you all remember from high school biology, right? The heart has these four chambers, the two upper chambers and the two lower chambers. On looking at Corey's heart from the outside, all that could be seen was an epicardial contusion on the front of the heart. The epicardium is just the lining of the outside of the heart. So he has a visible contusion on the outside of the heart. But it wasn't until the heart was opened in such a way that you could see inside each of the chambers that this laceration was revealed. On the left ventricle, which is the lower left chamber of the heart, that's the muscular one, that's the one that pumps blood out to the rest of the body. There was a tear in the tissue. Dr. Ragasa described it as about 1.5 inches, and that comports with the photograph. A horizontally oriented tear near the tip or apex of the heart into the muscle. It didn't go all the way through the heart wall. It was just a tear of the heart muscle in the internal surface of the left ventricle.
Doctor, did you review images 206 to 220?
I did.
And can you tell the jurors about that?
This was a series of images of scalp contusions. Corey didn't have a lot to see externally on the scalp. There was maybe one abrasion or contusion near an eyebrow. But when one looked at the skin or underneath the skin, there was a contusion on the top of his head and a couple of contusions on the back side of his scalp that you couldn't see on the surface.
Doctor, did you make any findings regarding bruising on the decedent's body, which was significant in regard to your formulation of your opinion?
Well, in assessing the potential for child abuse, it's not so much that contusions are life-threatening in and of themselves, but it's the pattern and distribution of injuries and also the presence of injuries of varying ages that suggest that a child has been mistreated. And Corey had contusions over a wide area of his body of varying ages, from under his chin, his head, his trunk, his extremities. There was one fairly large one just on the left side of his chest that looked to be fairly large, and that had been previously assessed. And particularly the presence of contusions on the back without a pretty clear-cut explanation it's not diagnostic of abuse, but it's very suggestive of abuse, certainly given the company that it's keeping. So my concern was not so much with the severity of the bruising, but the pattern and distribution of the bruising as being suggestive of child abuse.
Doctor, did you make any findings regarding the decedent's liver?
Yes.
And can you tell the jury?
Well, as I said, there were two injuries. One of them was fairly minor. It was on the front edge of the liver, and it was a contusion. That's not particularly uncommon after CPR. But there was a second, more significant injury, and that was out on the right side, the right lateral edge of the liver. It was described as a superficial contusion, but the photos clearly show that it's a contusion that goes fairly deeply into the liver tissue itself. And under the microscope, this was not a super fresh injury, so this was not an injury that could be attributed to CPR. So those are the two findings involving the liver.
Doctor, were you able to formulate an opinion as to the time frame when these blunt force trauma injuries were inflicted?
Only in a general sense, giving a range of time. To dispense with the contusions first, many of them were sampled under the microscope, and many of them were pretty much all healed, or mostly healed. You could see something on the surface of the skin, but not much going on underneath it. So other than to say on my gross inspection of these bruises, they appear to be of varying age, that's as far as my opinion regarding the bruising. The internal injuries, on the other hand, have a little more objective evidence to offer in terms of timing. And the basis for that is something called the inflammatory response. So what does that mean? When tissue is injured, there is a fairly predictable sequence of events that occurs in the body's attempt to repair itself. That's what inflammation is, or one type of inflammation. So that inflammatory process involves the appearance of certain kinds of repair cells to the area of injury at a fairly predictable time, within a fairly predictable time frame. So I examined both and I did not generate new slides. These were slides that were done at the time of the original autopsy. So slides of the heart injury and slides of the liver injury. And in both of those injuries, there was a fairly well-established acute inflammatory process there. Though the cells that make up the acute response are called, I've got to say it because they have a name, they're called polymorphonuclear leukocytes. Wow. Let's just call them polys. So polys are recruited to the scene within hours after an injury like this. The second wave of inflammatory cells are called mononuclear cells. Those were pretty rare. I only saw those here and there. After that, and those, take up to like 24 hours to get there. And then after 24 hours, you actually start to see some attempt to heal the tissue. Fibrins laid down, and you see other cells called fibroblasts. Those weren't present. All I was seeing was this acute inflammatory process that was fairly well established. And that was in both the heart and the liver. What does that mean? Well, that means that, in my opinion, these injuries occurred at roughly the same time, and their age could have been as recent as 4 hours, but as old as 12 hours prior to when Corey actually died at 5 p.m. on the 2nd. That was the finding based on the histology. Additional evidence that I saw fine-tuned that time frame a little tighter.
And doctor, can you tell us about the additional evidence that you saw to fine-tune that time frame?
So if you think about that time frame of 4 to 12 hours, that would have been from 5 a.m. the day before to about 1 o'clock in the afternoon on the 2nd. There was a video that was alluded to, and it wasn't an intentional video, and there were no people in the video. You could basically see that the phone was on a car seat or something. Attorney Lento, have folks seen this video? Do they know what I'm talking about?
Mm-hmm.
So it appears as if the phone was like on a car seat or something. And it was represented to me that this was Corey's mother dropping him off for custodial care with his father. And they were having a conversation. Well, this was at about 9 o'clock. Corey was answering questions. He was conversational. He was normal. Audibly. So if that's at 9 o'clock, the period of time of injury from 5 o'clock to 9 o'clock, in my mind, is eliminated. A person with these injuries is not going to be responding like Corey would in the car. So that puts us between 9 a.m. and approximately 1 p.m. I can't narrow it down any more specifically than that, but I am confident that that is the range of time in which Corey was injured.
Doctor, can you explain to the jury if there was any opinion or determination or findings that you made after review of the materials regarding blunt force trauma and CPR post-mortem?
Yes. I was specifically asked questions about that because I believe these were questions that were raised in the original autopsy report. In my opinion, given the age of these injuries, it is entirely incompatible with them having been produced by CPR because they wouldn't have had this inflammatory response that takes hours to develop. Furthermore, I don't know anybody who does CPR on the right side of the chest. CPR is done on the front of the chest. And like I said, the anterior liver injuries, not uncommonly seen with CPR, but not an injury out on the side of the liver that goes deep into the tissue. And thirdly, I've seen a lot of CPR injuries, more in adults than kids. Adults are, they have a lot of CPR injuries because our ribs fracture much more easily. But I've seen a fair number of CPR-related injuries in pediatrics. I've never seen an endocardial or an internal laceration of the heart like this one. So in my mind, I'm quite confident that these injuries are not CPR-related.
So, doctor, you were able to determine that the injuries occurred while Corey was still alive because of the inflammation.
Oh, exactly, yes.
Did you make any findings regarding sepsis or infection?
Once again, that issue came up on the initial examination. And based not only on the autopsy findings, but my review of the medical records, there's zero, not one scintilla of evidence of sepsis or any other infectious process in Corey's autopsy.
Doctor, did you note any findings regarding stress cardiomyopathy regarding the decedent's heart?
I did.
And can you tell the jurors what stress cardiomyopathy is?
Cardiomyopathy. So cardio refers to the heart. Myo is muscle. And pathy is pathology. So this is some sort of abnormality of the heart muscle. As the name suggests, stress cardiomyopathy, it is an abnormality of heart muscle that's produced by chronic ongoing stress. It's not visible to the naked eye. It is seen under the microscope. There are well-described changes of individual heart muscle, changes in the color, changes in the way the innards of each cell look under the microscope, changes in the way that the nucleus, the nerve center of each cell looks. These findings were pretty widespread in areas of Corey's heart. Some of the findings that are associated with what's been called stress cardiomyopathy, which is in the literature, are associated with CPR because the heart is dying at that point, and some of these findings can be seen also in CPR, but the constellation of all of these findings and the distribution of them throughout the heart says to me that this is not related to CPR, but it's related to chronic ongoing stress. So while Corey's immediate cause of death was the blunt impact injuries that he sustained the day that he died, the presence of stress cardiomyopathy suggests that there was ongoing physiological stress, most likely due to ongoing mistreatment or abuse.
Pictures. Your Honor, the state would ask for permission to publish certain photos that have already been marked into evidence. Counsel?
Mr. Lewis, you need a break all, you're all right?
I'm good.
Okay. So they're already in evidence, go ahead.
They are. Thank you, Judge.
Judge, just trying to get the technology to work.
All right. I think we need to, why don't we take a break, we'll do it. We need to adjust the TV. We go from using the TV for two different things, so we probably needed 2 minutes to adjust it. So ladies and gentlemen, go in the jury room for a couple of minutes, don't discuss the case.
All right.
Can you try to remote this?
It's partially working now. I'll get it working.
All right. It's 11:01 a.m. The jury's in the jury room. Any from counsel outside the presence of the jury?
There.
No, Judge.
All right,
No,
we'll take a
thank
break. Ms. Strong, if you could try and work that out. And
I will.
Back out. Thank you. I'll step off for a moment.
Your Honor, could we excuse the witness? Or
Sure, Doctor. You need to
No, Judge.
11:11 a.m. Jury out, please.
All rise. Jury out.
All right, thank you, ladies and gentlemen. We'll continue with the testimony. Ms. Lanza.
Thank you, Judge. If we may turn to what's marked S97, please, already in evidence. Doctor, we now have up on the screen S97. Can you please tell the jurors what that is?
That's a very small contusion. It looks like an abraded contusion, sort of a combination injury on Corey's forehead.
And is S97 a picture? Is S97 a photograph?
Yes, it's a digital image that was generated in conjunction with the autopsy.
Okay. And can you just explain again what's depicted in S97 in the photograph?
Okay. Your Honor, may I stand? Is that possible? And do you have
If
like
he
a...
could come down from the witness stand, I think he's having a little hard. You want to come down from the witness stand or stand?
Well, I could point from here if you had a pointer.
I think we do, actually.
I don't know if it's going to work. No, they weren't working.
Pointer is not working,
Hold on.
so if you may
I'm a short
come
guy.
down or
Yeah,
it's
Red
working?
button.
Oh, okay, we're good.
I don't know if it'll work.
Your
on
Honor,
the
just for
TV.
purposes of the record, we're handing the doctor the,
Understood. So doctor is standing in a witness stand and trying to use a pointer to point to the large screen TV.
Sure. And this is a...
That's not going to show up from the screen.
It's not good.
It's not going to work.
Yeah.
Okay, doctor, if you'd like to just come down from the witness stand, if that's,
Is that good?
Yes, sir.
thank you.
So it looks like we're looking at the left side of Corey's head. You see his hairline is here. This is just the outer edge of his eyebrow, the left side there. And that's Dr. Regas's thumb for a measuring device. So you can see a small abraded contusion that measures, no more than a half an inch, maybe 3/8 to a half an inch away.
Can we go to the next picture, please? Okay, and can you tell the jurors what S98, that photograph, depicts?
A contusion up behind the ear is, it really requires some sort of an explanation. That's an injury that at least raises, it's not diagnostic of, but it raises the question of mistreatment of a child.
And why would that raise that?
Well, because it's a protected area. It's not normally injured like in a slip and fall or something. Now, if you fall against something, that it could conceivably, press your ear, hard enough against that bony part, the masculine process there. But most of the time, at least in my experience, it's generally associated with other injuries that suggest mistreatment.
Can we go to the next picture? Can you tell the jurors what is depicted in S99, the photograph?
Just to orient you as to where we're at anatomically, this is Corey's left shoulder. Right? Left side of his neck, left ear. So there's this linear contusion, sort of brownish, yellowish contusion up under his chin. You can also see this is pretty regular. I suspect this was some sort of EKG monitor pad. So that's not an injury. See how regular that is? It's got a little hole in it. So the main thing here is this contusion under his chin.
And what's significant about that?
Well, the significance of a contusion under the chin in and of itself is very little. But in the context of examining a child with multiple injuries of varying ages in different parts of the body, particularly up under the chin and around the neck area, once again raises the question of whether or not that child has been mistreated.
Can we please go to the next photograph? Doctor, I'm calling your attention to what has been moved into evidence, S101. Can you please explain what has been depicted in that photograph to the jury?
In S101, Corey has been rolled up onto his right shoulder. So this is Corey's left ear, back of his head, right shoulder, left shoulder. What is being emphasized in this image are two contusions. Now, in and of themselves, is a little ditzel of a contusion, a dangerous thing? No. But a contusion over the shoulder blade and sort of directly over the spine in a child without some sort of history of how that came about is not an area that you typically see injured in the run and play and slip and fall of childhood. It is the context, it is the pattern and the distribution that makes it an important finding.
Can we move to the next photograph, please? That is S100. Can you tell the jury what that depicts?
So Corey is laying once again on his side, and we're looking at the hip area. So the buttocks would be down there, the back would be up here. We're looking at a fairly broad abrasion. And we talked a lot about contusions, but abrasions are a different kind of blunt impact injury. If force is applied sort of tangentially or sweeping across the skin, it can raise the superficial layers of the skin up, raspberry, right? And that's the kind of injury that we're seeing here. This is an abrasion, rather large, confluent abrasion over his hip. Again, the context is what makes that important. That's not a lethal injury. It's not a life-threatening injury. But in the context of everything else that we're seeing, it's a significant injury.
Can we please move to the next photograph? S60, doctor, can you tell us what that depicts?
This depicts a contusion or a bruise that captured a lot of people's attention. So this is Corey's right shoulder, armpit area. There's the right nipple. There's the left. Just above it, there is this vaguely patterned contusion. It's partially healed. It's fairly large, and it's in a very odd place, unless there's a good explanation for it. It was valued by several care providers.
Can we move to the next photograph, please? Now we have S59, a photograph. Can you tell the jurors what that is a photograph of?
This is an internal photograph from the autopsy, the internal aspect of the autopsy. And it's a picture of the liver. And in specific, the outer right side, that lateral edge of the liver. So on the surface of the liver, what you see is this. There's a little bit of bleeding, and you can see that the tissue is torn. But Dr. Ragasa made an incision right in the middle of this injury to see what was underneath it. And you can see that all of this is abnormal. It should be uniformly this color. What you're seeing here is a fracturing or disruption or laceration of the liver tissue, and that comes when the liver tissue is compressed in some way. And as I said, CPR is performed in the front. It's not performed out here on the side.
Doctor, is that a significant injury?
It's not a life-threatening injury. As ugly as it is, it's not a life-threatening injury. Had Corey presented with this and nothing else, they would have probably seen it on the CT scanner, and they would have put him in the hospital and observed him to make sure that he did not have ongoing blood loss, and then discharged him with some physical restrictions to let it heal on its own. So it's nasty, but it's not life-threatening.
Can we move to the next photo? Doctor, can you tell us what is depicted in S58, please?
This is likewise another internal photograph from the autopsy. In this instance, you're looking at the heart. Now, it doesn't look like any kind of a heart that you've ever seen before because it's been opened. So the heart has been opened to reveal the inner side or the inner surface of the left ventricle, the lower left chamber. What is seen here is an actual tear in the tissue. This wall should be continuous. There's a tear on the internal surface of the heart near the septum. The septum is that muscular wall that divides the left from the right side. So he's got a partial thickness tear of the heart on the left, inside the left ventricle.
Now, doctor, can you tell the jurors about the severity of the tear and the relation to thickness?
This is a severe injury. This is an injury that triggered Corey's death. Why? Well, he didn't bleed to death. This laceration didn't go all the way through the heart muscle. It's not a hole in the heart. It's not a tear that goes through the heart. In that case, there would have been an enormous amount of blood loss very quickly, and he would have never survived as long as he did. In this instance, in that it was partial thickness, his heart could, at least for some hours, compensate for this injury. But I had mentioned the septum. The septum is where these specialized heart cells that control the rhythm of the heart live. So you've got these natural pacemakers on the upper part of the heart, and then they divide into fibers, specialized fibers that go down the septum. Disruption of this can trigger rhythm disturbances, arrhythmias of the heart. That's likely what happened to Corey in the CT scanner, why he went into cardiac arrest. With CPR, they were able to restore some sort of normal rhythm, but couldn't maintain it. He kept going into, I believe it was a rhythm called ventricular tachycardia, and they ultimately could not resuscitate him from that. So that's how this injury mediates his death. It's not, trauma, bleeding, exsanguination. This is trauma. The heart tries to compensate, the heart eventually decompensates, and he sustains a cardiac arrest due to his trauma.
Now, doctor, are you able to view the inflammation which you spoke about before in that photograph?
No. The inflammatory process is something that you see under the microscope. So Dr. Ragazza took samples, well, from other areas of the heart as well, but from in and around this tear, and that's where I saw the inflammation that allowed me to draw an opinion or come to an opinion as to the age of that injury.
Could we go to the next photo, please? Doctor, I'm now showing you, or it's up in the courtroom, what's been marked into evidence S152B. Can you tell the jurors what that is?
I received this image subsequent to my initial report, but I received it in conjunction with this question about timing. We already talked about the video at 9 o'clock. It has been represented to me, and I believe there's been some sort of analysis of the photograph that indicates it was taken, on or about 2 o'clock in the afternoon. To me, I don't know, Corey could be sleeping, But it's certainly not inconsistent at all with him already having had sustained what were ultimately his fatal injuries. And he presents an hour later to the emergency room looking not much different than that, save for the fact that his vital signs were unstable and his color was ashy.
So, doctor, would that photograph be consistent with your opinion regarding the timing of the blunt force trauma injury?
Yes?
Can we move to the next photo, please? Oh, I think we are done. Okay, if you could go back to the witness stand. Thank you. Now, doctor, in conclusion, based upon everything that you have reviewed, what is your medical opinion regarding the cause and manner of death of Corey?
Corey Micciolo died of blunt impact injury of the chest and abdomen with laceration of the heart, contusion of the left lung, and laceration and contusion of the liver. It's a traumatic cause. The manner of death is homicide. It was at the hands of another person. He didn't do it himself, and it didn't happen accidentally.
Thank you, doctor. No further questions.
Mr. Lucci.
Thank you, Judge.
How are you, doctor?
Good to see you.
Good to see you too. You been to Hanover lately?
I have been to Hanover fairly recently.
All right, let's get to it.
Yes, sir.
Did you review all the police reports in this case?
I viewed police records. I cannot say for certain that I saw every single police report.
Do you
I
recall?
saw some.
I'm sorry, I didn't mean to interrupt you.
I saw some.
Did you review Detective Mitchell's 29-page synopsis of the case?
I did.
Okay. Did you review the records from Dr. Harry Larkin?
That name is not familiar to me.
Okay. Did you review the records from Southern Ocean Medical Center?
Yes, sir.
Did you see any records in there from Dr. Larkin?
I don't, that name, because I don't look for names, so I can't recognize the specific name.
Did you review Dr. Ragazza's medical examiner's report?
I did.
Did you review his findings?
I did.
Did you review the community medical center report?
Yes, sir.
And did you review Jersey Shore's medical report?
I did.
Did you review Southern Ocean Medical Center report?
Yes.
Did you review the grand jury minutes in the case?
Grand jury minutes. I'm going to refer to my report.
Yeah.
I don't see it listed on my initial report or any of my supplemental reports.
So you were hired by the Ocean County Prosecutor's Office sometime in September of 2021, right?
Correct.
Okay. And do you recall if that was prior to the medical examiner issuing his report?
No, I believe it was after.
So are you still in New Hampshire?
I retired from state service in 2017. I maintain a consulting practice, and that is the role I'm playing here today.
Prior to reviewing the file and agreeing to become an expert, or maybe after you agreed to become an expert, did you have an opportunity to speak to Ms. Lento?
Yes.
Did you have an opportunity to speak to Ms. Schroen?
We communicated primarily via email. My primary discussions were either with Detective Mitchell or Attorney Lento.
So you did speak with Detective Mitchell also?
I did.
And when was the first time you spoke with Ms. Lento?
I don't recall specifically. I received the initial material for review, and we very likely had a conversation via telephone sometime between my receiving the material in late September and the issuance of my first report in February. So we undoubtedly talked one or more times in that interval.
And did you also, you said you spoke to Detective Mitchell, right?
Yes.
Okay. Do you remember when you spoke to Detective Mitchell?
No, those were primarily conversations regarding transmittal of documents, timing, and scheduling of conferences with Attorney Lento.
So when you spoke with Detective Mitchell, and you've already testified that you read his 29-page report, did you notice anything in there about one of the medical examiners from Ocean County County, from Dr. Harry Larkin?
This is starting to ring some bells.
Oh,
I believe Dr. Harry Larkin might have been the initial responder from the Ocean County Medical Examiner's Office, and please correct me if I'm wrong.
I will.
No doubt. I believe he is the one who ordered the postmortem CT scan on the body of Corey Micciolo.
Now, and he's a medical examiner from Ocean County, right?
That's his title. I don't know what his credentials are, but that's his title.
And you were a medical examiner, right?
Yes, sir.
And the medical examiner is the one that actually physically does the work that you just testified about.
As far as autopsy goes, yes.
Right. So when you were a medical examiner, you were the one that did the slides, right?
I obtained the specimens. The laboratory generated the slides.
And you're the one that would open up the body.
Yes, sir.
You're the one that would remove the organs.
Yes.
You're the one that, as we saw, the liver was opened up, right? You're the one that would do that.
Yes, sir.
And would you also take those pictures, or somebody else would take the pictures?
Depends on the agency. In New Hampshire, I take my own pictures.
So Dr. Larkin ordered a CAT scan after Corey had passed.
Yes,
right?
sir. Yes, sir.
That's very unusual, right, for a medical examiner to order a CAT scan after somebody passed.
Again, that depends on the jurisdiction. Some offices are really like Baltimore. They're very well endowed. They have a CT scanner in their office. So for them, it's not unusual. I don't know what the standard is in Ocean County. I certainly don't routinely, or did not routinely do it in New Hampshire. So in New Hampshire, unusual. Baltimore, another day at the office, and everything in between.
So it was unusual then for Dr. Larkin to order a CAT scan in New Jersey.
I don't know what the standard is here. I don't know how often it's done.
But he also ordered blood work at that time, right?
That I don't recall. I recall the CT scan, and he certainly would have had access to the blood work that was already done in conjunction with the resuscitation effort. But I'm not aware of any additional lab work he ordered.
Are you aware of the blood work that was taken from the decedent after he had passed?
The only thing that I'm aware of that was taken post-mortem was the toxicology specimens that were taken in conjunction with the autopsy by Dr. Ragasa.
How about the blood work taken before he was deceased?
That would have been the blood work taken by Southern Ocean. Is it Southern Ocean?
It is Southern Ocean Medical Center.
During the resuscitation effort.
And are you aware that in that blood work there was a high white blood count, high glucose level, and high lactic acid?
Yes.
And Dr. Larkin found that was indicative of
Objection,
sepsis
Judge.
and infection.
Councilwoman Brooks?
Yes, please.
gentlemen, the objection is sustained. Mr. Luce is going to rephrase the question.
Do you recall what Dr. Larkin's position was with the Ocean County Medical Examiner?
I just knew he had the title of medical examiner. I don't know his credentials or know what his specific role was.
Now, you reviewed a number of reports in order to come up with your conclusion, am I right?
Yes.
One of the reports you just testified that you reviewed was Detective Mitchell's investigation report.
Yes.
Did you rely somewhat on that report to make some of the conclusions you have here?
In terms of timelines and that sort of thing, yes.
So, did you ever go, you never went to Southern Ocean Medical Center, right?
Correct.
Okay. You never saw Corey, right?
Not physically, no.
You never ordered any of your own tests, right?
No.
You never ordered any of your own CAT scans, right?
No.
You just reviewed results of other people.
Yes.
And you relied on whatever they did to make your decision.
That's fair.
Okay. So, you did read the report where Southern Ocean Medical Center's CAT scan, you know what the result of that was?
Yes.
Okay. And the result of that was that there was an indication for extensive airspace disease in his upper lungs consistent with lung disease. And you did read that, right?
I read that, yes.
Okay. And you also read the x-rays. Did you see the x-ray reports from Southern Ocean Medical Center?
I remember the x-rays from Jersey, but I can't remember the specific wording of the x-ray reports from Southern Ocean.
Okay. So let's use Jersey Shore then. At Jersey Shore, you're aware that they yielded negative results for any injury.
Yes.
Did you review or go through any of Dr. Dante Ragassa's reports?
Yes.
Okay. So, Dr. Ragassa is actually the medical examiner in Ocean County. Or one of them, I guess.
One of them, certainly. He's the one who did the autopsy, the original autopsy on Corey.
So he's the one that did everything. He's the one that took Corey. He's the one that did the whole entire autopsy.
Yes.
Now, he reported on a number of injuries, just like you discussed, and he said that they were due to life-saving techniques.
Yes.
Okay. Are you disagreeing with that?
Yes.
Now, you're also disagreeing with the results of the CAT scan showing disease, lung disease?
I'm not disagreeing with what the CAT scan shows. The CAT scan shows what the CAT scan shows. My disagreement is in the interpretation of that CAT scan. This is a post-mortem CAT scan read by a clinical radiologist. Post-mortem CT scanning is occasionally used, but it takes special training to interpret the results of those postmortem CTs because they don't look the same in dead people as they do in living people. For example, the appearance of lung disease is simply a manifestation of blood no longer flowing through the lungs. Whatever blood is there, it's not moving, so blood is contrasted with air, so it looks like airspace disease. Furthermore, Corey had a well-demonstrated confluent contusion of his, I believe it was the left lower lobe. Now, the CT scan describes upper lobe stuff. But a contusion on a CT scan, these are lights and shadows. This isn't having it in your hand. A contusion on a CT scan would look like pneumonia. So my disagreement is not in what it shows. My disagreement is in what it means.
But you do disagree with Dr. Ragassa?
With regard to...
Life-saving.
Yes, these are not CPR injuries.
So, now, that's a contrarian view. You would agree with me? You go contrary to what the medical examiner here in Ocean County said.
No, I don't think it's a contrarian view. It is a second opinion, and as a matter of fact, was reviewed not only by Dr. Regassa's supervisor, Dr. Falzone, the chief medical examiner for the state, but was taken before a child fatality review committee. Dr. Regassa subsequently changed his report to reflect that this was a homicide.
And wasn't that after your report?
Yes.
So, the Ocean County Medical Examiner changed their report after you gave them your report.
That's my understanding. Yes, sir.
So, do you recall a case that I believe you did medical examiner on called Patrick McCarthy?
Yes.
Patrick McCarthy, I believe, was a 10-year-old child.
Yes, he was.
And in that case, you were in fact the medical examiner.
Yes.
So you were the actual one that did all of the physical work.
Yes, sir.
Okay? And in that case, you said, as the medical examiner, it was not a murder.
I did.
Okay? 6 experts, including Dr. Bonin and the FBI, said it was a murder.
No, I don't believe that's true. There were experts that said it was homicide. Likewise, there were a number of experts who agreed with me. And it was my understanding that the FBI, save for one agent who was very, let's say, emotionally connected to the case, was insistent that it was a homicide. New Hampshire Fish and Game, New Hampshire Crime Scene Unit, New Hampshire Department of Justice, and the prosecutor, the federal prosecutor in New Hampshire, all agreed that indeed Patrick had died of hypothermia. Now, there is disagreement. I never changed my determination based on what others said because I did not find it credible. Nevertheless, the family has indeed, for I think it might be 20 years old now, has established a website that portrays me as Satan incarnate because I'm, quote, covering up a homicide. So yes, I don't think I'll ever forget that case.
Now, you kept using a word on direct exam where you would say, not of diagnostic value. What does that mean?
I think I was using that phrase in the context of some of these contusions. Like, taken individually, one contusion is not diagnostic of child abuse. Multiple contusions and varying stages of healing distributed over a suspicious area on the body is far more suggestive of inflicted injury than an individual bruise, which is not diagnostic.
So, are you saying that if Corey was struck on the right hip by a blunt force, that it would cause the laceration you see in the heart?
No.
Are you saying that the injury to the chest? By the way, how old, if you know, how old was that injury to the chest?
Which injury?
The one that's not the one that was due to the hospital, the one in the middle of his chest.
Oh, the bruise on it? Don't know.
Okay. Can you age bruising?
To some extent. It's not nearly as reliable as inflammation internally. There are some criteria to use for aging bruising, but it's not as reliable.
So if that bruise was caused 12 days prior by the treadmill, and between the treadmill, we know that he played football, he went to football practice, he was in his mother's care, he was in his father's care, he was in his grandparents' care, could that heart contusion have happened on March 20th and persisted all the way through April 2nd?
No.
We just saw a series of pictures of different injuries that you say that Corey received. Can you say with any degree of medical certainty whether any of those injuries that he sustained was what caused the injury to the heart and the liver?
None of the skin injuries, the contusions, can be correlated with what was seen internally.
Now, you also said that initially you put your opinion that it occurred between 4 and 12 hours, right?
Yes,
And then you changed your opinion based upon certain things that you were given afterwards, right?
incorrect.
Okay.
I did not change my opinion. My opinion was amended or modified on the basis of new information. The basic opinion was still the same. The time frame was narrowed because of additional evidence that suggested that he couldn't have possibly have sustained those injuries prior to 9 o'clock.
So now when you met with Detective Mitchell and you met with Ms. Lento, did they discuss with you that if you put it between the 4 and 12-hour period, that he would have actually been in the care of his mother for some of that time?
Well, I knew that he did not get dropped off for custodial care to his father until 9 o'clock. So whether or not they mentioned it, I knew that that was the case.
So now you're stating that you saw a 33-second video of a child speaking to his mother. By the way, is that diagnostic or not diagnostic?
It certainly aids in the diagnosis. It is not diagnostic in and of itself. However, a child is not going to respond in that fashion if he or she has already sustained those ultimately lethal injuries.
So in the 33-second video, do you recall it, by the way?
I'm sorry.
Do you recall it?
The video?
Yeah,
Yes, sir, I do.
Okay. Do you recall that in the middle of that video you hear Corey moan?
No, I don't recall that.
Okay. Do you recall in the middle of that video you hear Corey yawn?
Yawn?
Yawn, like, ah.
I don't recall that.
Now, you also said that you saw a picture of Mr. Gregor that we just saw on the couch with Corey. And you said at that point that he could have been asleep. By the way, is that picture diagnostic value or non-diagnostic value?
It is of aid in reaching it is not diagnostic in and of itself. It's consistent with the time frame that I think this injury pattern occurred in.
So you're saying based upon a 33-second video and a picture, and ancillary things to show you when that picture was taken and when that audio recording was done, that changed your whole opinion on the 4 to 12 hours?
No. It modulated or amended the opinion. These injuries were of fatal potential, and they would have been certainly responsible for a change in Corey's demeanor and behavior. Therefore, behaving normally at 9 o'clock precludes that portion of the original range of time. Therefore, the clock, if you will, must by necessity start at 9, but it certainly doesn't go beyond 1 o'clock.
So, with that contusion to the heart that you showed us, by the way, I'm not a doctor, but let me show you it's been marked as states S. I'm assuming that's the heart.
You're on point.
Good. Thank you, Doctor. Can I hand you a Sharpie?
Sure.
Can you circle the contusion?
This is the...
That's evidence that the jury's going to be able to take into the jury room. I don't. Can we photocopy and have them do it if you want them to circle?
Thank you, Judge.
Sure.
I don't want to open the evidence, so.
Are we off the record while that's being done? Or?
Because I'm going to ask you to circle.
We're not on the record, we're on the record.
Okay, to be clear, it's not a contusion. It's a laceration.
I'm sorry.
It's a tear of the skin. I didn't know, just wanted the record clean.
Well, that's done. Can I ask you a question?
Should only take a second, there's a copy machine right in the hallway, so, or like a neat paper or something, a toner or something like that. But, otherwise, under normal circumstances, you should be quick. What you can do is we'll mark it as S58A and S59A. You can show it to the doctor. You can hold them side by side if you want to mark up the paper photocopy. You can do that, Mr. Bruce.
Thank you, Judge. Oh, yeah. So, that's the liver, right?
This is the liver.
And that's the heart.
This is the heart.
Can you draw a circle with the marker where the laceration on the heart would be?
Your Honor, these are crap. You know, the thing is, I can make my best guess based on these images, but
Judge, how about we do this? Would it be all right if I handed him a Post-it, and he puts the Post-it on their exhibit as an indication of where the area of the laceration is?
What's the state's position?
Your Honor, I don't think that we should be marking evidence that's going into the jury room. That wasn't the purpose of it. It was an autopsy photo.
The doctor went up to the TV
Yeah.
screen and he showed where the
We could do that with the doctor as well, too. You could put the picture up if you would like. That would be different than actually documenting.
I think you look at the actual evidence. You can't compare the two of them together and point out where on the photocopy it is. I understand it's dark, but
it would only be a best guess.
if you can't answer, doctor, with a reasonable degree, then
I'm not comfortable with it.
Okay. How big was the laceration?
It was described as, and there's no scale on it, it was described by Dr. Ragas as being 1.5 inches in length.
Do you see it?
Yes, sir.
Okay, is it about 1.5 inches
It
deep?
certainly appears to be.
Okay, and how long would a person live with a laceration of that size?
It's not a matter of size. It's a matter of where it is and what it's doing. It's not going to cause blood loss because the heart's still intact, but it will disrupt the electrical activity of the heart, which can only be compensated for a limited period of time. In Corey's case, it was from the time he was injured till the time he was pronounced at 5:00 p.m. It's not going to be the same for every individual. Some people would die sooner. Some people may die after a longer period of time. It would certainly not be instantaneous.
So in Corey's case, you're saying that he could have lived for 4 hours with an 1.5 inch laceration to his heart.
Given where it is and what it is, yes.
And you're saying that to a reasonable degree of medical certainty.
I am.
Thank you, Doctor.
Any reader?
I do, Judge, thank you. Doctor, are you aware that Dr. Larkin is an investigator with the medical examiner's office?
I don't know who Dr. Larkin is. I know he's...
You don't have
I-
any information that he's the actual MA?
Right,
Oh.
right.
And it was actually a radiologist at SOCH who did the postmortem CT scan?
They read it, yes.
And why wouldn't you rely on a post-mortem CT scan in regard to determining cause and manner of death?
A postmortem CT scan has to be interpreted in the context in which it's taken. In this context, it was simply a reflection of Corey having been deceased and did not aid in determining a cause or manner of death. Reliance on the CT scan to say he had pneumonia is utterly without scientific basis.
Now, do blunt force trauma injuries always leave bruising on the body?
Not always, and especially in the case of children who have fairly elastic qualities and plasticity to their skin. You can apply blunt impact injury over a broad enough area to transmit force inside the body and internally injure the body without leaving a contusion on the surface of the skin. That's not impossible.
And doctor, can you explain how that is possible?
It's possible because of the quality or the characteristics of the skin, particularly in pediatrics. Now, in a person who is not 6 but 66, different story. But pediatrics is unusual in that regard.
And does the force of the blunt force trauma have any impact?
It depends on the magnitude or the strength of the force. Obviously, a bump against an object is different than a blow that transmits enough force into the body to lacerate internal organs. So it depends on the magnitude of the force.
Did you make any findings, or were there any significant findings regarding Corey's toxicology results?
The only findings in Corey's toxicology results were medications that were given in conjunction with his attempted resuscitation. They gave him naloxone, which is an opiate
I'm going to object. It's outside my cross-examination. I didn't talk about toxicology.
He talked about blood work, Judge, that's why.
You did ask about blood work.
Yeah.
So it's allowed in that respect, overruled.
Thank you.
which is kind of routinely given in hospital circumstances and unresponsive people, given the ubiquity of opiates. But the rest of them were medications that were resuscitation related.
And can you tell the jurors who Dr. Falzone is?
Andrew Falzone is the chief medical examiner, was at the time. I suspect he still is. Chief medical examiner of the state of New Jersey.
And did he review this case?
It's my understanding he did, yes.
And did he speak to Dr. Ragasa about that?
That's what has been represented to me, yes.
And after that, did the Ocean County Medical Examiner's Office determine that the cause of death and the manner of death is homicide?
That's my understanding.
Objection, Judge.
Judge, he cross-examined on it.
Well, you actually asked the same question.
Yeah.
Worded slightly differently, not the same result. So we're,
Thank you, Judge. No further questions.
any reproach?
No.
All right. Thank you so much, Doctor. Thanks for coming in. I see counsel on sidewalk. First, ladies and gentlemen, with respect to some of the testimony, experts are frequently asked questions on direct examination and cross-examination about whether they relied upon conclusions or findings by other physicians. That's why you're allowed to hear that testimony. The testimony about whether some other doctor talked to another doctor, both of them aren't here, that's all hearsay. So to the extent you remember that, you should disregard that. On whether it was either elicited by the state or by defense. At this point, we have some challenging scheduling issues that I want to talk to the attorneys about. So before we break for lunch, what I'm going to do is ask you to go into the jury room, and I'm going to try to give you a prediction of where we're going to be going with respect to the remainder of the case, given those scheduling issues. So I ask your patience just for a little bit. We'll have you out here by 12:30. Thank you so much.
All right.
Please be seated. It's 12:11. The jury's in the jury room. We're on the record. So normally, the state would rest, not be calling any additional witnesses, and then the defense would put on a case if it chose to do so. We have this one problem where the state has an additional physician who is out of the country. Which was brought to everyone's attention a long time ago, but the anticipation was that we would be otherwise filling the days between now and then with other testimony. That physician is not going to be available to testify until Wednesday, May 22nd. Mr. Gallucci has agreed that the state can essentially continue its case on May 22nd. Under Evidence Rule 611, the court has the ability to control the order, manner, and mode of interrogation of witnesses, and I find that both sides are already advised of this issue, and the state is willing to have that witness testify before Mr. Gallucci calls Dr. Bodden, the defense expert. So first I would like the position of counsel as to how we explain to the jury that the state's resting, but not completely, pending that person on the 22nd, and then admittedly, we don't have enough witnesses to fill the trial days between now and the 22nd, so I'm proposing that in terms of the jury coming back, it would only be next week, Wednesday and Thursday, the 15th and 16th, and then the following week, the 21st, if there's still witnesses available, or I should say necessary to be called, the 22nd for Dr. Feingold for the state, the 23rd for Dr. Bodden for the defense. Obviously, there'll be some other incidental things we have to discuss. I'll have to do the defendant's testimonial election outside the presence of the jury, whether he chooses to testify or exercise his constitutional right to remain silent. So I'll hear from counsel as to how to explain to the jury that the state's resting except for this additional witness and why we're having these challenging scheduling issues.
Judge, are we allowed to take a very brief break to discuss it together?
Sure.
And then come back?
I mean, even if we go a little bit past 12:30, the jury's going to be released for the day anyway, so
Thank you.
we don't have to worry about a lunch break. And then we may have additional days, for instance, we discussed tomorrow whether we're going to conduct hearings outside the presence of the jury, and some other days perhaps. So we'll make use of that time. But sure, I'll step off the record for a couple minutes, discuss how you want to proceed, and then let me know if you want to write up something that you both agree upon for me to say to the jury. That's fine too. I suggested that last night, but just for completeness of the record, there was a request by counsel that does not have the jury back until May 20th, and I declined to do that. I think that's allowing the jury to be absent too long a period of time, allowing things to fade in their minds, and perhaps be influenced by outside sources. While I gave an analogy yesterday of, well, we could break a trial over Christmas. Let's face it, we try never to do that. We don't want to give the jury a 12-day break. So having considered over the evening and nighttime, I don't want to break on May 8th to May 20th in a child murder case with all this attention. I want to keep the jury coming back more often than that if we can, even if we do something like today where it's not a complete day. So with that in mind, I'll give you a few minutes to think about it, and we'll see how we address the jury.
Thank you, Judge.
All rise.
Jury is still in, the jury room is 1223.
The state has additional.
Guess we need Ms. Rowan back. What's your back in the program? All right, counsel, how do you want to proceed? What kind of discussion would you like to have?
Judge, I had approached the state regarding the upcoming instructions for the jury on how we're proceeding. My suggestion, which I believe for the most part the state agrees with, except for the last line, was something along the lines of due to challenging scheduling issues, given the number of witnesses and their schedules as well, but also in the interest of proceeding forward as expeditiously as judicially possible, and then the court articulating the schedule. I did add a line which the state disagrees with, that nothing in this schedule suggests that the burden of proof ever leaves the shoulders of the state. Just because we are going out of order, it's obviously our concern as the defense, while we're happy to do so, knowing the scheduling issues. We knew this issue was coming, given the last witness the state has. We're happy to do so. We just would like the reminder in there of the burden of proof always resting with the state.
And that's going to come out multiple times in the final charge as well. So, first, should we, instead of terming this, the state is resting, should we say instead, the state is not resting until Dr. Feingold, however, in the interest of moving forward, I've allowed the defense, under my ability to control the order of witnesses, to call witnesses out of order so we can still utilize some of these days. And the state agrees with that.
Judge, that's what we wanted to place on the record, that would be our preference.
I mean, there's nothing wrong with me saying, as always, the state must prove the charge beyond a reasonable doubt.
Right, but I don't think that's really relevant as to charging the jury regarding a scheduling issue.
Well, the relevance is be able to establish proof beyond a reasonable doubt under a certain standard at the close of the state's case, allowing the benefit of all its favorable testimony and all favorable inferences which can be drawn from that testimony.
I mean, he still could potentially have defense witnesses after that. So
Right.
It's not like we're putting on our witness last where there's this need to have this charge. He's still going to have defense witnesses.
I just gave that's the
Yeah.
conclusion of the expert charge.
Right.
The ultimate determination of whether or not the state has proven the defendant's guilt beyond a reasonable doubt is only made by the jury. So we
Right.
just did that yesterday and today when Sergeant Coles and Dr. Andrew were qualified as experts. I mean, I don't think there's much risk the jury's going to
Right.
flip the burden of proof just because you call witnesses out of order. So,
It's just not the normal way you would normally
Right.
do it, and my concern, because we cannot ask the jurors any questions, we don't know what's in their mind, it doesn't hurt to give the charge to just, again, underscore where the burden of proof lies.
In addition to that, I agree to everything that we're talking about. And I will have Dr. Bodden on the day, on the 23rd.
Yeah.
But if Mr. Gregor decides he's going to testify, the decision on when he testifies is a decision that I want to be in control of.
Right.
So if, say, Dr. Bodden is to testify on the 23rd, I don't want to be committed to the fact that I have to end the day there. If Mr. Gregor decides he's going to testify, I may want to do Mr. Gregor after that. I may want to do him before that. I don't know, as I'm sitting here right now, when he wants to do that, or if he wants to do that.
I mean, that's a constitutional magnitude. Obviously, you call him until any time, until the case is over and you rest. So,
Thank you.
I don't, he wants to testify before that or after that. I mean, typically that's the decision made at the very end of the case. The defendant has the right to make that decision.
And he more than likely probably wants to hear what Dr. Bodden has to say.
What I don't want to suggest to the jury, though, the reason I was talking about Feingold and Bodden available the 22nd and 23rd, I don't want to suggest to the jury that he might testify and then he doesn't. I never want to bring that up.
No. I'm saying, why say anything? Why? Let's keep it generic. That, we're going out of order.
Right.
Because of this reason, without using their expert and my expert as the reason. Just use a generic, whatever Ms. Ferrante just came up with, without using the state is calling Dr. Feingold and Mr. Gallucci is calling Dr. Bonin. I don't know why we have to do that.
Okay, I don't know that I was intended to say that to the jury. I said that to each of you to talk about scheduling, because we know that Feingold's can't get here until the 22nd. But what I said was, I think jurors may have some basic knowledge that the state rests and then they stop calling witnesses. So we're going to say the state's not resting because they have an additional witness, I don't have to identify who that is, and that counsel requested and the court has authorized the defense to begin calling witnesses out of order before that last state witness. And this is the anticipated schedule: next week the 15th, the 16th, the following week the 21st, 22nd, 23rd, and so on.
That's fine, Judge.
All right, so why don't we try to write this down again. Ms. Ferrante, would you tell me what you had said before?
Due to the challenging scheduling issues, given the number of witnesses and their schedules as well, but also in the interest in proceeding forward.
Hang on, I'm not the court
Sorry.
reporter.
Forgot that.
Do the challenging scheduling issues, number of witnesses and their schedules?
Yes,
Go ahead.
but also in the interest of proceeding forward as expeditiously as judicially possible.
Go ahead.
And then the court would articulate what the schedule would be. And the older their request from the defense is there something at the end of that. I think I crafted it as nothing in the schedule suggests the burden of proof ever leaves the shoulders of the state. Something along those lines, Judge, is what the defense is requesting come at the end of the scheduling being articulated.
All right, and so I could say something like this. Due to the challenging scheduling issues, the number of witnesses and their schedules, but also in the interest of proceeding forward as expeditiously as judicially possible, the defense will call witnesses out of order before the state has rested its case. Counsel has agreed to this, and as I have control over the order and manner of questioning witnesses, I have approved it. Then I'll tell them the schedule, or perhaps even before I tell them the schedule, I was going to say, as I previously instructed you, the burden of proof always remains upon the state to prove the charges beyond a reasonable doubt.
It's fine, Judge. It is what it is.
All right. Jury out. Anything else before we come out? 12:32 p.m.
Jury out.
Thank you. Please be seated, everyone. All right, ladies and gentlemen, as I indicated to you, we had some challenges with respect to witnesses. So we've agreed that due to the challenging scheduling issues, the number of witnesses and their schedules, and also in the interest of trying to proceed as expeditiously as judicially possible, that the defense will be calling certain witnesses out of order before the state actually rests its case. The attorneys have agreed to this amongst themselves, and as the judge, under our rules of evidence, I have the ability to control the order of the witnesses testifying. So I've authorized it, and there's times in the past I've done it as well, because say a witness was leaving for vacation tomorrow, so we fit them in today, for instance, before they left, even though it was out of order. Well, in this case, the state has to wait for an additional witness who won't be available for several days. I'm going to tell you the schedule in a moment, but as I previously instructed you, the burden of proving the charge beyond a reasonable doubt always rests upon the state, and that burden never shifts to the defendant. So our challenges are a couple of things. We don't have witnesses available on either side until next week, likely the middle of next week. Counsel had previously indicated that there was a family medical issue on the 14th that prevented everyone from being here. So what I'm proposing is then we basically have a week from today till next Wednesday. And it's longer than I wanted to go, but again, I'm going to give you the instructions about not being influenced by any outside sources. So the plan would be April 15 and 16 of next week, and then the following week, not Monday, but Tuesday, Wednesday, Thursday, the 21st, 22nd, and 23rd. Then we're coming up towards Memorial Day weekend. That's likely going to be near the end of the case, but probably the following week, right after Labor Day, would be, that's our estimation, when we can have closing statements and my final instructions to you. So that means you get the case for consideration beginning right after Memorial Day. That would still be a week earlier than I told you the outside. So even if it took you all week to decide the case, that would be a week earlier than the outside date I gave you of June 7th. So regrettably, we just have some off days that we didn't expect. But as you can see, we have one witness from New Hampshire, we have other people traveling far, plus obviously physicians have commitments which are difficult to break. So we appreciate your understanding in that regard. What I wanted to do was be able to give you a sheet of paper with those dates, because I imagine you need to explain to your employers and things like that why you're showing up one day and not another, why you have breaks like this. So counsel, did you see that paper? You agree to that?
Yep.
No problems with that? If you do have any issues come up before we come back, for instance, that you're something that you should be bringing to my attention right away, you can contact the jury management, and they'll advise me, and we'll determine if there's a way to get all of us either on a video or a telephone call or something like that to discuss that with you. So this is not unusual. Things come up. You'll have a trial right before Thanksgiving where you end up having a break till after Thanksgiving or before other holidays or things like that. So here it's a combination of all the factors I've just given you. But it's very important now that you remain strong about following your oath and not being influenced. So, for instance, if you start telling your employer these days you're going to be in, they may start guessing what case you're on. So I would ask that perhaps you share that with somebody who's your direct supervisor that is going to keep it confidential, and when you share it with them, you say, but I can't discuss anything else other than these are the days I'm going back, for that reason. And it's because we're going to have a significant break. I'd ask you again to please remember, during this or any other recess, don't start discussing the case amongst yourselves. You haven't heard all the evidence, and even when you hear all the evidence, you need to hear the summations and get my final instructions on the law, which include how you go about deliberating. Don't discuss this with your friends, your family, your coworkers, except simply to say you're still on jury duty and it's going to continue. Don't text anyone, phone anyone, email anyone, have any conversations about any of the persons, places, issues, charges, attorneys in this case. If you start talking to someone else, that person's going to tell you what they think they know. And it's probably wrong, but it's certainly hearsay. It's not evidence. We have rules of evidence for a reason. Only admissible evidence can be considered. The only admissible evidence in this case is what happens in the four walls of this courtroom and nothing else. If you did talk to someone, they're going to have an opinion. That's going to affect the way you think, and it's going to be unfair to the attorneys because they won't know about it. They won't be able to address it. And as I said, it's not evidence. Don't read or look for any news articles, whether in print or on the internet or any Facebook page, any live streaming or anything like that. Don't try and do any investigation. Don't look up any locations on Google Earth or other internet sites. Again, you're not allowed to be investigators. If you were investigators, you couldn't be jurors. You can obviously continue to use your electronic devices, but I'd ask you to avoid things popping up about this case. If you see something like that, don't be tempted to start looking. Please understand that you've taken your oath as jurors. You've been sworn in this case to decide the facts of the case from the evidence introduced in this courtroom and absolutely nothing else. It would be unfair and a violation of your oath as jurors to base your decision on something that you learned outside the courtroom. So my assumption is we'll be ready at 9 o'clock on the 15th, but I'm not entirely positive of that right now. So what I'll ask the jury management to do is to email you. I've tried to bring you over here each morning as soon as we can. There's always issues that come up. So I'm sure you've been sitting over there wondering, like, why aren't we coming over to the courtroom each time? But if I think we need to start at, say, 9:30 or 10 that day, I'll ask jury staff to email each of you to tell you that. But right now, just plan on the morning of April 15th, about 9. But if you got here at 9:30, we would wait for you. So as I explained to you, the most important people in a jury trial, most important goal being to have a fair trial, but you're the most important people. So if you're running late one morning, then you don't have to worry about it. We won't start without you, obviously. Counsel, anything further before we release the jury?
No, Judge, thank you.
No, Your Honor.
So, ladies and gentlemen, I have to thank you so much for your understanding and your cooperation with regard to this entire process. I'll see you next week. Please follow my instructions. Please remember to take all your things.
Did everybody get one? I have one in my hand. Everybody got one?
My papers.
Sorry.
Thank you. I got it already. See you next week.
At 12:42, the jury is out of the courtroom. We did discuss tomorrow we would have some hearings. Mr. Bellucci, will you be able to get any witnesses available?
I think I'll have 2 witnesses tomorrow morning.
All right. So we'll just do whatever we can in the morning then?
All yours.
Yeah, 9 o'clock or
Sounds good.
works for the
That's
state?
fine, Judge.
All right, so we'll continue tomorrow with hearings outside the presence of the jury at 9, but the jury won't be back until the 15th, April 15th.
Can I have that?
So we're recessed for today.
Thank you, Judge.